Welcome to today's program titled Be Prepared, OSHA Enforcement Trends for 2024 and Beyond. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Daniel Birnbaum. Dan, please go ahead.
Thanks, Donna. Could you go to the next slide, please? And the next slide again, please. Thank you. Well, we appreciate you joining today. We have a very full agenda today, which I'll go over right now. Obviously, OSHA has stepped up their enforcement recently with inspections up 50% over the last 2 years, which includes everything from employee complaints, which are also up 50%, injuries and referrals. And with hundreds of new compliance officers being hired who are both new to the job, which means they have less experience and might be a little bit more overzealous, we view today's presentation as very timely for you. So we're here today to talk about OSHA's enforcement agenda. We're going to cover whistleblower considerations and penalty and liability policies. And then in the second half of today's presentation, we're going to get a little bit into some more substance of what exactly OSHA is going to be focused on in this upcoming year and the future beyond, which includes a new national emphasis program, heat illness, and workplace violence. I would like to stress that you have the ability to ask questions and answers during this presentation. We encourage you to do so, and time permitting, we will try to respond to your questions. But if there's anything on your mind that we do not cover today, we also encourage you to submit your questions, and a member of our team will respond to one of your questions and provide you with an answer if we don't cover it today. Donna, could you please advance to the next slide? And the next slide again, please. So just to set the groundwork here, a little bit of an overview of OSHA liability, which some of you may be aware of, is that the employer's responsibility over its own employees. And generally, it's divvied up into two sorts of categories. Recognized hazards, which falls under OSHA's general duty clause, and hazards identified in specific regulations. And as we're going to discuss during the second half of this webinar, a lot of the emerging issues that have come in the modern workspace, including workplace violence or heat illness, hasn't traditionally had specific regulations that have governed it. And OSHA has regulated it through their general duty clause, which we'll talk about in terms of how that impacts both enforcement and an employer's strategy in defending against those sorts of citations. But we're also going to talk about, especially for our friends out on the West Coast, certain states that have their own state plans and have specific regulations that cover things like workplace violence and heat illness out in California. So wherever you're situated, whether you're federally under OSHA's federal jurisdiction, maybe on the East Coast, or you're under a state plan state such as in California or Washington or Oregon, how these issues divvy up are going to differ based on where you're sitting, which we'll talk about today. Donna, could you advance to the next slide, please? Another part of the emerging workspace is the realities of a multi-employer workplace. Traditionally, having employers would have their own employees that they were responsible for, but as the workplace has grown and developed and evolved, now, of course, there's other sorts of workers who are present on the work site. And liability can attach to the person who obviously operates and owns and hosts the work site, but also for our friends on the line who have temporary workers or send their workers out into other workspaces. Now you have liability where it may intermingle in that regard. And so we'll talk about these issues and the citations that can result, even if technically it might not be your own employer, you don't consider them your own employee, and the criminal prosecution that can also result, which we'll discuss as well. Next slide. So as referenced, these are some of the categories we look at when we consider the different employers or employees who are on site, contractors, subcontractors, temporary employees. Really, this is a list, but it's not an inclusive list, and as the workplace continues to develop, it's possible other categories could get added to this. The key, of course, is that we can't really be constricted to looking at our own operations. We have to look more holistically at the workplace as a whole, which is how OSHA observes it. Next slide, please. And just to jump into it a little bit more in terms of the analysis, the critical issues are looking at the documented paperwork and the contractual relationship and intermingling between you, your company, and these other employees in terms of who's responsible for what, who's supervising who's helping to train which employees, who's providing which equipment to others or is responsible for filling that gap. And generally at a 30,000-foot level, just understanding who's exercising control over the workforce in a practical reality, even beyond what's written in the contract. And then the critical issue as well being that if there is an imminent danger or something shows up at the work site, the host employer being able to immediately step in and stop that work. Next slide. So setting the table further for our discussion today and why OSHA citations matter. For those who have familiarity with OSHA, obviously when OSHA shows up, they're able to issue citations with penalties. And the penalties can range anywhere from tens to hundreds of thousands, or in extreme cases, millions of dollars, which is the immediate concern to most employers on OSHA citations. But what we're going to talk about, and a theme to understand in today's conversation and webinar, is that in defending against OSHA citations, it's not just the immediate citation that should be of concern, but the road, looking down the road in terms of what sort of future exposure you may open yourself up to. And that includes repeat citations when you have a substantially similar occurrence down the road, which will set you up for increased penalties and have the jump from the tens of thousands to the hundreds of thousands of dollars in penalties. Or willful citations when you violate the act or allegedly violate the act with plain indifference, how that can also set you up in a significant jump from the tens to hundreds of thousands in penalties. The other things that can result from OSHA citations and inspections are liabilities for third-party litigation, and critically for business reputation, and certain contractors that understand that even if you get one OSHA citation that might have a nominal penalty, it can put a significant restriction on the amount of business you can get going forward, especially in light of the fact that there are third-party services that can be hired by clients or potential clients who can investigate your OSHA history. And in fact, anyone, the general public, can go on OSHA's website and go on their establishment search and put in the name of your company and find out if you have any OSHA history. And the third-party tracking services, which we discussed, and customers, clients, labor organizations, really anyone who can get access to this and use it or misuse it for their own benefit. So there's value clearly in proactively understanding what OSHA is going to be looking at, taking the steps today to prepare for that, so that the sort of cascade of issues that can result from an OSHA citation don't result. Next slide, please. Oh, and at this point, I would like to turn it over to the next speaker, Patrick Joyce, to talk about whistleblower considerations. Patrick.
Thanks, Dan. Good morning or good afternoon, everybody, depending on where you are. Thanks for joining us today. Wanted to take a quick detour here outside of the kind of OSHA enforcement realm that you may be used to into whistleblower retaliation claims. Now, this is parallel to OSHA enforcement because these OSHA, these whistleblower retaliation claims are investigated by folks at OSHA, by OSHA investigators who are part of the Whistleblower Protection Division. They're different from the enforcement folks that you may be used to who come into your plant to do investigations after an injury or after a report of an incident. So these first two items here, what are they and when can they come up? They're kind of interrelated to each other. OSHA investigates a total of 25 different statutes that have whistleblower protection provisions associated with them. You may be most used to OSHA 11C. You've probably heard that terminology before. That comes out of the OSHA Act. That is kind of the basis for what we're talking about here today and the rest of our presentation. But there are many other statutes that may seem unrelated to safety that have whistleblower protection provisions associated with them that OSHA handles. So, for example, Sarbanes-Oxley has whistleblower protection provisions, and OSHA investigates those. Even though you may think it's totally unrelated to safety, if it's protected, it's investigated by OSHA. Some other ones that OSHA investigates have to do with the environmental statutes, such as the Clean Air Act, Toxic Substances Control Act, and also transportation-related statutes, Air 21 for the airline industry, the Surface Transportation Act for trucking and distribution and that type of thing. So there's, like I said, there's 24 other statutes that OSHA investigates beyond the OSHA Act. Some states have their own whistleblower protection provisions that can be investigated concurrently with the federal investigations. For example, Michigan has its own Whistleblower Protection Act. So does the state of Washington. There are many others out there. And sometimes you may be used to seeing, or maybe you've seen this in the past, where you get an OSHA complaint where they come and investigate the work site from a safety perspective, but at the same time, there's a whistleblower complaint where you get a letter and you're asked to respond to the whistleblower complaint. So these things can all happen in parallel. Most of the time in these whistleblower protection provisions, you will be told who the whistleblower is, who the person is who's making the complaint to OSHA, whereas that's different than you would expect from OSHA when they come on site investigating a safety-related complaint, where they are actually typically prohibited from, and hold that very closely, those protections of the complainants. When it comes to these whistleblower complaints, the worker who makes, so let's focus on the safety related ones for a second here. For 11C, the worker has to have a good faith, reasonable belief that there's a safety concern. It doesn't have to actually be a safety related issue. They just have to have a good faith, reasonable belief that it's related to the safety of the workplace. When it comes to the other statutes, it's the same thing. If there's a violation, say, of Sarbanes-Oxley, the whistleblower just has to have a good faith, reasonable belief that it violates the applicable statute. We could spend an entire webinar going over the various elements of a whistleblower complaint and how to respond to them and that type of thing, but I'll just set them out quickly here. You have to have a protected activity. So, for example, you have an employee come and say, hey, I think this issue is unsafe. I think this item is unsafe. We need a machine guard here or something like that. That's going to be a protected activity. There's also other sorts of things that are considered to be protected activities, such as providing information to government agencies. The act of filing a whistleblower complaint or the act of complaining to OSHA about a safety-related issue is a protected activity. Otherwise, helping a government agency in an investigation, providing testimony, that's protected. Doing activity such as filing a grievance under a collective bargaining agreement can also be considered to be protected activity. So there's a whole host of items that can be considered protected activity to get the whistleblower under this investigative statute. When it comes down to it, then for there to be a claim, if the whistleblower, it makes it known that they have a concern to the employer, there has to be employer knowledge of the complaint, which can either be actual, they directly talk to the employer, or it can be suspected or inferred. Something happened, there's a complaint to OSHA, we think this person made this complaint. So if that is known by the employer, by the person who ultimately has the decision-making authority or is influenced by others, that brings you within this realm. Finally, there has to be an adverse action for these whistleblowers for them to be protected by the statutes. Not just discharge, but also demotions, changing to different undesirable shifts, reduction in pay, the good old cold shoulder where you stop, you stop talking to this employee. That has been considered by OSHA to be an adverse action. And then, of course, we've got the legal jargon here where we start talking about a nexus or a causal connection between the protected activity and the adverse action. And depending on the various statutes that you're under, those can be different triggers. And for example, contributing factors, a motivating factor, or a but-for cause. When it comes to the filing and response procedure for OSHA whistleblower complaints, there's supposed to be a gatekeeping function that OSHA performs. A lot of times this doesn't actually happen, where they're supposed to take in the complaint, analyze it, see if there's any there, as the saying goes, and then bring it up to the employer. A lot of times we find that they're just so overworked at this point in time that they don't perform that gatekeeping function. And then our clients and employers have to respond to whistleblower complaints that maybe don't have a basis. OSHA will ask you for a response in written form. We always recommend providing a response, getting legal counsel involved if you need to, or at least having someone who's competent to prepare the response, putting it together. And then OSHA will investigate. Sometimes they just will dismiss it. Sometimes they will move forward with the interviews of employees to confirm what was put in the written response. And in certain cases, if they find merit to the complaint, then there is an opportunity for the employer, or if they find no merit, there's an opportunity for the whistleblower to appeal that up the chain. When it comes to a statute of limitations, this is important because there's a varying amount of time that the whistleblowers have to file their complaint, everywhere from 30 days under the environmental statutes and OSHA 11C, all the way up to 6 months under some of the most recently reauthorized or the new statutes, such as the Surface Transportation Act and some of the Food Protection Act. So lots of information here. Donna, if you could move to the next slide. So one of the best practices we have been able to provide to our clients for avoiding whistleblower complaints is if someone comes to you with a concern, with a safety related concern, or otherwise, if it's under one of the other statutes, pay attention, make them feel heard, do an investigation, make sure that you are taking the steps. Don't just brush them off, don't just ignore them. A lot of times that is the best way to avoid getting on to a complaint to the agency and having to respond to a whistleblower complaint. Of course, there are certain circumstances where doing all of those steps, taking all of these steps, doesn't actually protect the employer from a complaint, but it's been found to be a good way to do that. So now we're coming back to our presentation coming off our detour, and I'm going to kick it over to Scott.
Thanks, Patrick. Donna, we can go to the next slide. So Dan mentioned earlier some of the penalty structure with regard to OSHA citations, and you can see that they increased it on January 15th of this year, so a couple months ago now, or coming up on a couple months, and they do tend to increase each year. Last year they were 15,625 and 156,259 in those sort of varying buckets there. So you can see there is a decent increase, and as Dan mentioned, these can ramp up, particularly to see the failure to abate. That's a per day violation. If you're sort of not in a position to abate and that racks up, that can move pretty quickly, move the financial needle pretty quickly. If we go to the next slide. We also refer to criminal liability, and this is something that has increased of late. we would say that there are increased referrals to DOJ for criminal prosecution, or to even state DAs, local DAs. And for the purposes of criminal enforcement, under OSHA investigations, you typically are investigating an entity, or that's how it's perceived. When it comes to criminal enforcement, you do have sort of a broader definition. A corporate officer, director, can be the employer and can be personally held. You've seen recently, in fact, some cases that have fines, as we just talked about, in the millions of dollars. And you also have multiple folks in the corporate structure who have been found guilty of criminal activity surrounding the underlying circumstances of those violations, even pleading guilty to certain activities under related referrals to criminal liability here. So it's something that OSHA, including the Solicitor of Labor, has pointed out that they're trying to enhance that enforcement coordination to, presumably deter others from similar violations, to expand OSHA's reach a bit. And that's something to really pay attention to in not only not only on a day-to-day basis, but when you're looking at an instance that results in a fatality. Even if it doesn't appear initially work-related, it's something to pay attention to, because that's something where the investigators, the inspectors, they're going to look more in detail there. You're going to have potential liability where there's that fatality, where there's been a regulation violated. You need willfulness. There needs to be willfulness that needs to be proved by OSHA, or for the referral, investigated. And then the violation was what caused the fatality. Those are sort of the four criterion to yield that potential referral and potential criminal liability. You see on the slide that there are more than negligible results from actual conviction, or if you plea out, 6 months imprisonment, 500,000 for the employer, the company, or even 250,000 fines for individual respondents. So these are things to really pay attention to. Again, even if at first glance you don't see willfulness, this was an accident, it wasn't actually a work-related incident. Nonetheless, you need to be paying attention to prepare your response, to make sure folks are on the same page in investigating, and to consult competent counsel to prepare your defense against any potential criminal referral by OSHA to another enforcement agency, a criminal enforcement agency. If we go to the next slide, we'll see here just some of the potential avenues. Again, we talked about referrals to state folks, and you do have the potential for state law actions here, and the liabilities that can result there, the criminal charges that can result there. Under the OSHA Act, there are specific potential actions that can result in this criminal law liability, and those include obstructing or interfering with an investigation, an inspection. You can't provide advance notice. That's under 17F of the OSHA Act. Then there's falsification of records or statements made. Those are going to be under 17G. Those are prohibited. And when you're sort of lying to a federal inspector, falsifying records, there is a potential under the U.S. Code for prison terms up to 5 years. So it's something to be taken really seriously. It's not something to be just tossed aside and say, well, OSHA is not a criminal agency, so I don't have to worry about it, because they are, again, increasing their coordination with criminal enforcement agencies like DOJ and like DAs at the local level. If we could go to the next slide. And the next one, we're going to talk a little bit about sort of how we get here. Certainly when OSHA shows up, actually before OSHA shows up, you should be prepared, have a response plan in place, know who is within the company responsible for responding, be ready to connect with your counsel for advice on how the investigation is going to work. They can start through a number of avenues. OSHA can start through a complaint. a report to the agency about a serious injury or an illness or a fatality. Through emphasis programs, which we'll talk more about the warehouse and distribution center national emphasis program later in the presentation. But there are others out there, for example, regarding heat, combustible dust, other areas where OSHA is focused and may target particular industries to start those investigations and the inspections. And Patrick already spoke to you about OSHA whistleblower complaints. Again, sort of a different program area with specially trained inspectors, investigators, but nonetheless, OSHA does have a broad responsibility for those things. And you may see in the context of inspections, either an on-site inspection, which there are a number of criteria that need to be met for that to occur, but alternatively, OSHA could connect by phone, follow up with a letter or fax, require something like a rapid response investigation for an injury, which would be more paper. And if the employer is able to sufficiently respond, you could head off an inspection, an on-site inspection. And obviously, we look to keep these things narrow and to focus on the subject of the investigation. The fewer boots on the ground, the sort of less likelihood that the inspection could go broader. And so anytime you can kind of limit the upfront, either by responding sufficiently to, through a written avenue, or responding to a rapid response investigation, filling out the required forms there and providing, sufficient evidence on your response, that could limit OSHA actually coming to your work site, and that presumably would be sort of the better option rather than having folks on site. If we could go to the next slide. So aggressive enforcement, we have seen an uptick, as we said, in the number of enforcement activities and complaints. There are a number of ways that OSHA can sort of up that and leverage its resources, its somewhat limited resources, to get its broadest impact. The Assistant Secretary for OSHA currently is Doug Parker. He came from Cal OSHA, which is generally a jurisdiction that prioritizes enforcement, I'll say euphemistically, and he's arguably brought sort of that mentality here to the federal level. A lot of, during the Obama era, we did see regulation by shaming. Dan mentioned, or his slides referred to press releases. And the Obama administration, as well as the Biden administration, does use press releases to shame employers, to point out failings, to sort of, again, it's a deterrence effort to try and impact similarly situated employers in the same industry or geographic area. And in particular, the Obama administration and former Assistant Secretary Dr. David Michaels actually pointed to a study by Matthew Johnson, who's a labor economist, or at the time was at Duke Stanford School of Public Policy. And his study suggested that a single OSHA press release can have the same impact as 200 plus inspections. And that's, you can see why, with limited government resources, the agency might choose to issue a press release trumpeting a big fine, a number of violations. It's serious efforts to combat issues in the workplace safety space. We'll note for you that if you contest those citations in the press release, and you successfully get them modified down or even vacated, there's not going to be another press release telling the world that they were unjustified in the first instance. So again, that deterrence aspect is still out there, but the brand damage that Dan mentioned earlier may also be something to consider and that you'll have to address going forward. You'll see on the slide, we're talking about things like use of interpreters. You can certainly see OSHA send out bilingual inspectors to areas where they may anticipate multiple languages are spoken beyond English. OSHA, I think, relatively recently got the authority to issue UNT visas for certain areas to protect people's potential involvement in their inspections. you could see obviously previous inspections used to justify willfulness. So if you've been issued a citation on a certain topic previously, OSHA may come back and say, hey, you know that this is wrong. We told you this before, and then you're in that space that Dan mentioned about repeat and willful violations. They can also certainly ask for, request root cause analysis, or if you've done your own inspection or investigation to determine the cause of an accident, for example, OSHA may ask you for that. And that's another reason to potentially get counsel involved early to possibly establish privilege if that's something you want to protect or at least consider protecting. We're also seeing, obviously, the enhanced use of the general duty clause. There are a number of rulemakings going on that are in areas that there aren't specific regulations. For example, workplace violence, that one is focused sort of in health and social services. Heat illness is another area that has been on the rulemaking agenda seemingly for a long time. But in the meantime, while there's no specific reg, you might see OSHA use that general duty clause to pursue violations, to pursue citations. One other thing to note, or a couple other things to note, is increased collaboration across DOL enforcement agencies, for example, with regard to child labor. That's a huge focus of the government as a whole, the current administration as a whole. And even though wage and hour has primarily responsibility for child labor enforcement, you do see that OSHA's regulations when it comes to workplace safety cover everybody. So if wage and hour sees an issue with safety while it's investigating a child labor issue, or if OSHA sees a child labor issue while it's investigating safety concern, those two agencies can refer back and forth. And we've seen a number of press releases recently that talk about fines issued by one, investigation ongoing or contemporaneous with the other. And so those kinds of things are another way that the agencies can combine resources and potentially strengthen their enforcement activity. The other thing to keep in mind is that 2024 is an election year. We're talking about current priorities and what we might see going forward. If there's a change in the administration, a second term for the prior administration or a second term for this administration, that could impact how these things go. We do have an idea about track records from both folks, obviously, because they've both been presidents before. But a switch back to a Trump administration could lead to more compliance assistance and some reduction in these aggressive enforcement techniques that we've been talking about. There may be a turn, less of a focus on the vulnerable workers that it seems DOL has been focusing on during the current administration. And there could be more of a law and order focus targeting, so-called bad actors, which we talked about criminal liability. That's something that may actually be maintain continuity across administrations. There may still be a focus on that criminal piece, but these are all sort of things to keep in mind as you plan and prepare and speak with counsel and others to figure out the best way to mitigate your risks and to enhance your compliance activities, no matter the administration. So moving to the next slide. We just wanted to mention a couple additional sort of policies in place or programs in place that OSHA uses to leverage its enforcement ability and to target employers. Here, you'll see employee by employee citations, also known as instance by instance or IBI. This would allow OSHA to basically increase those penalties we talked about by issuing citations for each instance relating to a separate machine, location, entry, or employee. So those penalties will ramp up real quickly when it's not just sort of one issue. Generally, it's instance by instance. So there's multiple citations for those separate instances. And you'll see there's reasons, certain criteria that need to be met there. Before this policy that went into effect in March of 23, this was sort of limited to the egregious, the kind of most severe citations. But now a number of the most commonly cited standards, such as lockout, tagout, machine guarding, falls, trenching, respiratory protection, permit required confined spaces, and other than serious violations relating to record keeping are sort of swept up in this potential instance by instance program. So it's something to pay attention to for sure, because again, it can ramp up your citations and your attendant fines very quickly. The other thing we have there listed on the slide is the severe violator enforcement program. OSHA considers certain fatality and non-fatality catastrophe inspections, as well as all egregious cases, to be SBEP cases. And those, when you get dropped into that SBEP program, that includes mandatory follow-up inspections, and it could lead to increased awareness of the actions pushed up to sort of the corporate level. It could lead to corporate-wide agreements or enhanced settlement provisions. And also there's the potential for OSHA to use its 11B of the OSHA Act to pursue contempt proceedings for failure to comply with certain orders. So those are all ways that OSHA is ramping up its enforcement and its reach and its attempted impact, both on the ground and through deterrence efforts as well. And I think I will kick it over to Melissa now to talk about that national emphasis program that I mentioned earlier.
Thank you, Scott. Hi, everyone. Thank you for joining us. My name is Melissa Ortega. I'm an associate at Seyfarth's Workplace Safety and Environmental Practice Group. Today, I'll be discussing OSHA's latest national emphasis program, which targets warehousing and distribution centers. Donna, can we please go to the next slide? This program was announced in July of 2023 and is scheduled to last 3 years. The program is currently in full force, and we've already seen an uptick in inspections of warehousing and distribution centers. The program allows OSHA to direct its resources to these establishments, and for 2024, we can continue to expect more inspections of these facilities. Under the program, OSHA is going to choose establishments from 2 lists. The first are establishments with certain industry codes. And just to name a few, we can expect more inspections at couriers and express delivery facilities, local messengers and delivery, of course, general warehousing and storage, refrigerated warehousing and storage, and other warehousing and storage establishments. However, OSHA is also focusing, or OSHA's focus is not exclusively on warehousing and distribution centers. The second group that OSHA can choose from and will choose from are retail establishments with high rates of injury and illnesses. Some of these establishments include home centers, hardware stores, other building material dealers, supermarkets and grocery stores, and warehouse clubs and supercenters. Donna, can we please go to the next slide? OSHA's program indicates that the agency will conduct comprehensive safety inspections focused on hazards related to power industrial vehicle operations, material handling and storage, walking and working surfaces, and fire protections, to name a few. As it pertains to retail establishments with high injury rates, OSHA will focus on their storage and loading areas, so mainly in their back rooms. However, once on site, OSHA noted that it may expand the scope of their inspection when evidence shows that violations may exist in other areas of the establishment. So if they see anything in plain sight, they will expand the scope of their inspection. OSHA's program, just a quick note, OSHA's program is a federal program. However, the 22 states with state plans had to either adopt the federal program or establish a different but equally effective program by January of this year. During these inspections, OSHA will also assess heat and ergonomic hazards, so another thing to keep in mind. And this can result in further inspections if OSHA determines these hazards are present. Just a quick takeaway is that this program will lead to increased inspections and the possibility of citations and penalties. Employers with facilities that fall under any of the targeted industry codes should review their overall healthy and safe program, address any of the findings, and educate their safety personnel and managers on what to do if OSHA knocks on your door. Should your facility be targeted by the program and or you have any questions, please do not hesitate to reach out to any of us. And with that, I'm going to kick it over to Patrick to discuss heat illness.
All right, thanks, Melissa. Back to me. So Donna, next slide, please. So that title on this slide should actually have a question mark at the end of it. Will there be a new federal heat illness standard? That's a great question. So back in 2021, OSHA published what they call an advanced notice of proposed rulemaking. Lots of mumbo jumbo and jargon in the OSHA world, as you all probably know, the regulatory world, asking for comments from the regulated industry about how OSHA should put in place a heat illness prevention regulation, what sorts of triggers there should be in terms of heat, in terms of the temperature, what sort of protective measures there should be in place. The comment period closed. They had to extend it a couple of times. The comment period closed at the end of 2023. OSHA received very close to, not quite 3,000 comments from various players across industry, Chamber of Commerce, all sorts of different organizations, individuals, everybody who has their own ideas to what this should look like. OSHA has been trying to enforce heat illness through the general duty clause that Scott mentioned for many, many years now, trying to focus on, what's the recognized hazard, how to abate the hazard, how to protect employees, and that type of thing. OSHA has not been very successful when it comes to heat illness regulation through litigation. A lot of the citations that they've issued through the general duty clause have been dismissed by judges or by the review commission. A couple of them have stuck for very specific reasons, very fact specific to those particular instances. So OSHA has been then trying to get out of the general duty clause world when it comes to heat illness and put a specific regulation in place. But what they've found over the years and what is being shown through all these various comments is that it's hard to land on a specific regulation. Everybody's going to have a different idea. So really what they're trying to do, again, as Scott mentioned, there's a focus on the vulnerable populations of the workforce, those who work in agriculture outdoors, those who work indoors, who may be minorities or have particular vulnerabilities to heat illness, that type of thing. That's where the focus of the ANPRM is right now. We have not heard much from OSHA other than receiving the comments and occasionally extending the comment timeline since this initial filing. This rulemaking process, as we know, can take years and years and years. If those of you are familiar with the relatively recent, I guess it's not that recent at this point, Walking Working Surfaces Standard update that was in proposed status with different various proposals for the regulation for many years. And then all of a sudden it was out. And it took 15, 20 years until it came out in its current form. So it's possible that this could take as long. However, as I'll talk about in a future slide here, there has been movement on the state side. So maybe that is going to spur federal OSHA into movement here. Next slide, please. So at the same time as issuing this request for comments for an actual regulation, OSHA put out a national emphasis program for heat illness. What this does is it informs OSHA compliance officers when they arrive on site at a facility, whether it's a construction site or an indoor facility under these particular NAICS codes, to take certain additional actions should heat be determined to be an issue within that work site. So if it's outdoors and it's hot and humid, or if it's indoors and there's employees working around equipment or machinery that puts out heat, furnaces, that type of thing, or if it's just an enclosed building that doesn't have very good ventilation, OSHA has instructed its compliance officers to expand current investigations and sometimes even start investigations based upon this NEP. There's a set of questions that the compliance officers are supposed to ask. You can go online to the OSHA website and search for Heat Illness National Emphasis Program, and it will give you can find the actual set of questions that OSHA compliance officers have in their hand as they walk into your work site so that you know ahead of time what they might be asking for. It's going to be things that are listed on here. What's the training that employees have with respect to their exposure to heat, how to identify heat illness, the various signs and symptoms of heat illness, what sort of acclimatization is there for new employees or employees that return from being off or outside of the workplace to make sure that they can handle the heat at the workplace. And also, these are kind of the buzzwords that OSHA has been using over the years under the general duty clause. What is the employee's access to water, rest, and shade? Plenty of water, cool water, encourage them to drink water, that type of thing. Allowing employees to rest when they're starting to feel hot, and access to shady spaces to get out of the sun, to be able to cool down, and that type of thing. So that's where we currently stand. I have seen over the last 2 years since this NEP came out, dozens of inspections that were either expanded to include the heat NEP, where the compliance officer asked, hey, what training do you guys have for your employees? How do you make sure they have access to water? Do you provide them any sort of additional protective equipment, such as cooling vests, ice vests, that type of thing, to keep their core temperatures down? I have seen that happen across many different industries, both indoor and outdoor. That's something that's kind of unique about this NEP is it's indoor and outdoor heat illness. It's not just outdoor. It's not just agriculture. It's not just construction. Next slide, please, Donna. One of the things that has kind of also been difficult for OSHA to deal with when it comes to dealing with the heat illness under the general duty clause is its interaction with some of these other statutes that are listed here on the slide. Many years ago now, we had a heat illness trial where an employee was unfortunately killed by heat illness, and OSHA, during the investigation and during the trial, said that we should have treated this employee different because they were obese. Said that we should have asked this employee if they had any sort of underlying conditions that would have made them more vulnerable to heat illness, such as diabetes, cardiovascular disease, that type of thing. Of course, our response was, wait a minute, ADA, we can't ask those questions. So there is these types of interplays with the other privacy and health protection laws that are out there, where OSHA actually tries to say, hey, you should do this, but it does make it more difficult to identify employees who may be more vulnerable to heat illness. So therefore, you just have to treat everybody the same as is typical with these laws, and make sure that they're protected from heat illness in the workplace. Next slide, please, Donna. So we believe that federal OSHA may be looking to some of the states that have actual heat illness prevention regulations in place, some of them more recent than others, when putting together the framework of the national rule. As Scott mentioned earlier, Doug Parker, he came from California. California has had an outdoor heat illness prevention regulation in place for quite a number of years now. Originally, of course, it was aimed at agriculture and construction, but through litigation and through the actual regulation, some workplaces that we may believe to be indoors have actually been brought under the umbrella of this regulation, such as buses, where the doors open and close regularly. Bus drivers are affected by or exposed to heat from the outside. Workplaces where there's doors open all the time have been brought under this outdoor heat illness prevention regulation. In the future here, we have a proposed regulation from CalOSHA that's addressing indoor heat illness prevention with certain triggers at 87 or maybe 82 degrees, certain engineering controls or administrative controls that have to be put in place at those levels. That is expected to be voted on by the standards board pretty soon here, maybe even as early as the next March meeting, maybe April, with the idea of having it in place by the time the summer rolls around. It's already starting to get warm down in Southern California now, so they want to get this in place This could be a big deal for folks, let's say, focusing on what Melissa was just talking about in the warehousing and distribution area, where a lot of these warehouses don't have artificial cooling. And the way that the law is written right now, you may have to install artificial cooling AC in your warehouse to keep it under the 87-degree mark that is put out in the regulation. So definitely something to pay attention to. Colorado has had an outdoor heat illness regulation for years for agriculture. Minnesota has had one that is mainly focused on maintaining ventilation indoors. Oregon has just put one in place within the past couple of years, focused on both indoor and outdoor heat illness prevention, again, with certain triggers at certain temperatures. If you want more information about Oregon, I'm happy to provide that. I've done a number of webinars on that. And then Washington, where I currently sit, has put in place this outdoor heat illness prevention. They expanded an existing one to cover year-round, whereas before it was just during the summer, cover more temperatures. And there's the potential that this is going to expand to indoor in the future. So this is a big area where the regulatory bodies are paying close attention. All right, next slide, please, Donna. I'm going to read what everybody's been waiting for here, the CLE code. It is SS4587, SS as in Seyfarth Shaw 4587. All right, thanks a lot. And Adam, I'm going to kick it over to you to wrap us up.
Thank you, Patrick. If we go to the next slide, please. Good afternoon, everyone. I'm Adam Young from our Chicago office. A growing area of enforcement in our practice over the last few years has been workplace violence. We're seeing a proliferation of violent confrontations in the workplace and unfortunately fatal shootings. The big questions we get from clients are, one, what should we be doing proactively to prevent workplace violence? And two, how should we be reacting to concerning behaviors that we're seeing from employees, customers, clients, people who are associated with employees? So we're only going to have a few slides here, but we want to give you some practical tools about how to understand workplace violence, how to assess hazards, and what employers need to be doing under the law. First thing to understand is what is workplace violence. The active shooter is the most newsworthy, but it's really just the tip of the iceberg. Workplace violence is a range of behaviors, assaults of all types, including sexual assaults, but also threats, bullying, gestures. Those can all be workplace violence, and they can be key warning signs that portend a more serious violence to come that employers need to be reacting to. So those are the types of workplace violence. Let's go on to the next slide. And this addresses the different types of actors that can be the workplace violence assailants. We look at it as 4 different types. The first is the individual with no connection to the workplace, and that's the active shooter we see a lot in the news. For instance, Tops Friendly Markets, the terrible case in Buffalo. You have someone who just comes off the street and opens fire at that workplace. Type 2 is violence from a customer or client. This is a big issue in retail in particular, where where customers who come into retailers can engage in workplace violence. We also see a lot of patient-related violence in the healthcare area, and that's very heavily regulated. And then finally, employees who go to off-site work areas where customers or client homes can be a big area of workplace violence incidents. Type 3 is employees or former employees. That's employee on employee violence. The Aurora shooting here in the Chicago area, for instance, was an employee who was at his discharge meeting, pulled out a gun and opened fire on the young HR rep who was there in front of him. That's a big red flag here, right? Is if we have any potential for workplace violence, we do not need to do those types of meetings in person. Those can be done by phone, by Zoom, or by letter. Type 4, which we see probably the most of in terms of the anecdotes in our personal practices, as these relationships. People have relationships with people at the workplace. I've seen a lot of former boyfriends who are the sources of workplace violence. And it's really the majority of situations that I've personally dealt with. If we go to the next slide. The legal ramifications of workplace violence are many. Workers' compensation for injured workers. There's tort liabilities. And sometimes the individuals who are injured don't just include employees, but others who are at that work site. And then finally, OSHA enforcement. You've already heard about what the general duty clause is. There's no federal regulations on workplace violence, Outside of California, there's not a lot of laws on what employers need to be doing, but there is enforcement under that general duty clause. And I'll give you an example, would be the Integra Health Systems case. That's a home health care provider in Florida. An employee visited a client for healthcare services and made a lot of complaints that that employee made them feel uncomfortable. They did not like going there. He said inappropriate things. The company continued sending the young woman there, and the client pulled out a butcher knife and stabbed her. He then chased her down the street, stabbing her a total of 9 times and murdering her. And if you look up the name of that business now on Google, one of the first hits you're going to see is this incident, and a judge ruling that this employer did not do enough to protect this young woman, and it resulted in her being stabbed to death with a butcher's knife. So we need to ensure that no situation happens like that, for any employee, and that this is not the public-facing Google hit that you're going to find for your company as well. If we go to the next slide, please. What do employers need to be doing to address workplace violence? Hazard assessments, we highly recommend. Workplace violence prevention plan, we'll talk about it, but those are going to be required in California in July of this year. And then requirements, employees need to be required to report safety concerns and injuries as soon as they're reasonably aware of them. After you get those reports coming in, then you have to react. This slide deals with workplace incident assessment. So you have the reports coming in. What do you do? There's no regulations telling you how you have to assess incidents and what actions you need to take. But we advise clients to have a very systematic framework in place for analysis, right? It's not ad hoc. It's not one size fits all. Every workplace violence incident I've been involved with, I can tell you, is extremely different in terms of facts. We can't just have this one size fits all response because there's so many different ways that we may need to be addressing the situation and protecting our employees. And we developed these 4 levels in association with former FBI officials and attach different potential responses to each of them. Level 1 might be incidents like insubordination, disagreements that can normally be managed through the human resources function, but we need to track those because they can pretend future workplace violence to come. Level 2 is things like verbal arguments, concerns about potential violence, stress, self-victimization. I had a client whose employee used a Sharpie and wrote a target on his back and went around saying, "There's a target on me, there's a target on me." That would elevate maybe to more of a moderate threat. Level 3 is when we start seeing actual threats of violence, reports of violence, references to weapons. Level 2, we maybe just need to assemble a team to address and investigate. Level 3 requires an immediate response, removing that actor from the workplace, evaluating the issues, investigating. We may need to involve police at this point. And separations of employees, for instance, if they're taken away from the work site, they can be done by phone. And level 4 is the direct threats, right? Assaults, property damage, on-site weapons. We need to involve police immediately with something like that. So different ways to assess. Really need to react if we're getting complaints, if we're getting safety concerns. That's where employers have fallen down the most. And that's where most of the OSHA citations we see have come from. If we go to the next slide, I mentioned a California workplace violence standard that's become effective. Have to have that workplace violence prevention plan by July 1st. It's very onerous. We're helping a lot of employers on that. If we go to the next slide, please. Seyfarth has a tool called Survey Center, which has 50 state surveys that are completely free to anyone on this webinar, anyone at all who wants to look at them. We're happy to help you if you need access. There are many on firearms and firearms laws. So for clients dealing with that, how do we regulate firearms in our workplace? We've got a lot of Survey Center materials that can help you. If we go on to the next slide, please. A lot of what we do as an OSHA group is OSHA inspection management, how to manage inspections, how to communicate with OSHA, how to respond to letters from OSHA. And this slide kind of deals generally with that. We have a whole hour-long presentation we could do for you on communicating with OSHA. But first and foremost, we want everyone to be truthful and not get into kind of criminal prosecutions that Mr. Hecker was talking about earlier. Anything, we want to keep that inspection limited in scope and only giving them what they ask for. Anything that's used to expand the inspection can result in more OSHA citations and more liability for the company. We do have articles if you're interested on how to develop an OSHA inspection management policy, how to prepare employees for OSHA employee interviews. And we can make those available if you contact us as well. Absolutely crucial that people communicate with OSHA correctly and that they're prepared on their rights and responsibilities before they are interviewed. But turn things over to Dan.
Thanks, Adam. Well, again, I think we've had some time. We appreciate everyone asking some good questions here coming in. I think we've tried to address all of them. See some still coming in. If not, our contact information is being provided to you. These slides will be provided to you in the next couple of days. We encourage you to reach out to any of the presenters who presented on the topics or elsewise. We're happy to answer your questions and be in touch with you. Thank you again, and we appreciate you joining and look forward to hearing from you. Thank you.